legal analysis here. I want to bring in Rick Hasen. He's the author of the upcoming book, A Real Right to Vote. He's also a UCLA Law School professor and an election law specialist. Rick, thank you so much for being with us. So you heard what our colleague Caitlin Palance was saying there. Just walk us through your thoughts on whether or not the Supreme Court is going to be taking up this case if asked to do so.
So the court today did set up, it puts the Supreme Court in the hot seat, gives Trump only 6 days to write this petition on an emergency basis. And it's going to be one of the most significant things that the Supreme Court does in relation to the 2024 election. Remember, this Thursday, the court's hearing the Trump disqualification case, raises a totally different issue. But the court's hearing two very different cases that both potentially affect whether Donald Trump is going to be able to be president again. It's possible that the court is going to side with Trump on disqualification and side against him on immunity. The result would be that there would be a trial likely this spring in the federal district court, and there could well be a conviction or an acquittal before we get to the Republican National Committee convention this summer.
And just talk to us about the way in which the decision was written. Our Caitlin Palance, our reporter there, was just talking about how the judges literally hit back on almost every single argument that Donald Trump's lawyers put forward. Walk us through how forcefully and how definitively this decision was actually written.
Right. So the first thing to note is that it was two Democratic appointees and one Republican appointee to the court. They were unanimous. They issued what's called a per curiam opinion. That's an unsigned opinion for the court. Sometimes that's done to, emphasize that this is from all the judges. Sometimes it's done also because things are on a quick time frame and they all work together on drafting the opinion. It is unequivocal in stating that no one is above the law, including a president or a former president. We've never had a situation before where a president has claimed he's essentially absolutely immune, can do any criminal activity that he wants, and unless he's impeached for it, he can't be criminally convicted. It was a bold and very weak theory. So I'm really unsurprised by the fact that it was rejected. What did surprise me was the quick time frame. Everyone understands that this could well be what determines whether or not Trump can win the election, whether or not he's going to be convicted of these crimes. And so this fast tracks the case to potentially get back to the trial court. And it does so in a way that underlines the idea that no person is above the law.
And obviously, just for the purposes of Donald Trump's lawyers, the legal strategy and the political strategy, of course, intertwined here. I mean, they are going to want to delay. They want any sort of trial to be held, ideally, from their perspective, after the election. Just explain to us the process in terms of how they might try to run out the clock.
So they only have one option now to run out the clock, which is by Monday, they must file what's called a motion for a stay to put things on hold while the Supreme Court decides whether or not to take up the case on the merits. So the court is going to get this stay petition probably by Monday afternoon. It's going to get a response from the government. And within a few weeks, we should know the court's going to have really two options. Number one, it's going to put the trial on hold for months, which probably essentially means there will be no trial before the election. Or they're going to reject this idea of a stay. They're going to let this thing go to trial. If it goes to trial and Trump is convicted, he can then appeal, and those appeals can take potentially years. But and so he would not go to jail even if he's convicted. But what it does mean is this decision that the Supreme Court's going to make in the next few weeks likely is going to be the one that's going to determine whether we get this trial or not. If he loses there, he can go to the Court of Appeals and ask for something called an en banc petition to have the entire DC Circuit to hear the case. But if he does that, unless the DC Circuit agrees to hear the case, which I think is unlikely, then this trial is going forward.
And you mentioned, obviously, the other sort of key issue that the Supreme Court is going to be looking at this week on Thursday, and that is the Colorado case on ballot eligibility. Just walk us through how that's going to go from your perspective, do you think?
So that raises a whole different set of questions. It's not a criminal case. It's a question about ballot access. Can Donald Trump be on the ballot in Colorado? The Colorado Supreme Court said he can't be on the ballot because under Section 3 of the 14th Amendment, he's disqualified because he engaged in insurrection. Donald Trump then brought that case to the Supreme Court. The Supreme Court fast-tracked that case. They held briefing over a matter of weeks. And the oral argument on Thursday will pit those voters in Colorado who are trying to get Trump off the ballot against Trump's lawyers. The state of Colorado is also going to be weighing in there on its interests in this case. There's going to be hours of argument, and I expect that we will get a decision relatively soon from the Supreme Court, especially if they're going to disqualify him. Because, the thing is, when voters go to vote, they really need to know whether or not the candidate they might be supporting is someone who's actually eligible to serve in office.
Right.
And so, we will see.
Right. Rick Hasen, live for us there. Thank you so much. Appreciate it.